Well, we got an expanded panel. I undertook to sort of lob a few questions in the middle and see if they could get anybody talking. And so having three people having said that there should be flexibility in the trial requirements memorandum, I'm severely hopeful that when I ask this question, I get the answer I think we're going to get. Is the trial requirements memorandum so written in stone that there's no flexibility to accommodate specific cases and circumstances? Justice Farley. Please.
I think the most I can say is that it's a guide, capital G guide. Secondly, re-emphasize the desire to get down to how long the trial is going to take for scheduling purposes. Re-emphasizing that when you do that, and I think Peter, you made a very valid point. Don't get sucked into underestimating. You will save time by going ahead and admitting the obvious, and therefore most of the trials should be materially shorter than what you've been experiencing usually at 361. But certainly the court does appreciate and will make certain allowances so that there will be, what shall we say, a subconscious allowance for over-enthusiasm for cutting down the trial time if we feel that that's required. And secondly, there will be an appreciation that trials don't get stamped out the way hubcaps do at a auto parts place. They're not all the same, and there will be the occasional situation that arises, and we've got to be flexible with respect to it. It's a big juggling process, but we'll try to juggle so long as we get the cooperation from counsel, who are sincerely trying to help out and doing their case and helping out with the system as well.
Well, if I'm sitting down at trial requirements memorandum time and I see that I want to suggest a significant departure from what is required in the memorandum, how do I deal with that?
I think one of the best examples that I can give you there is that one of the interesting aspects that I've come across is that when counsel come in, and instead of me saying, well, have you thought about this and have you thought about that, they say, we've done all that, and as well we've done something else, and is there anything else you can think of? But quite clearly, if you wanted to do a departure from it, just as indicate, no, that's not really suitable for X, Y, and Z reasons.
Do you deal with that on a 930 or in the memorandum, or how do you get the judicial approval for a switch from the requirements?
What's your best bet with respect to advocacy in that particular situation?
Start with the memo and hope that gets you in the door?
Well, you know, maybe the best way to do it is through a memo, or maybe the best way is to come in and explain it to the judge. I mean, I think it's you're looking at the situation and saying, I think that the best way of explaining this is a memo first and supplement it afterwards, or just go in and talk to the judge about the situation.
Would you expect that to be the 9:30 judge sitting any particular day, or the judge is going to hear the case?
No, it will depend, Peter. I mean, sometimes it may be so early on in the stage that it would be the 9:30 judge. It may be a little later on where it's actually the pretrial judge in the combined sense. And I hate using the word pretrial because I think the pretrial conference now is such a dead dodo because it really hasn't. I mean, you got to shake things up about every 20 years because it just has been truly abused by the bench and by counsel, that in most circumstances it's not very effective. but you've got the settlement conference component, which may or may not be, as the civil justice review may not be at the same time, and you also then have the what I call the trial mechanics and what I think is called the case management conference in the civil justice review. So that may be the time to deal with it, or the case may be such that it's desirable to advise counsel a month ahead of time, 2 months ahead of time, as to the identity of the judge who will be hearing the case, and then allow the counsel to appear in front of the trial judge to work out the mechanics.
Now, perhaps I could just jump on to the next question. I heard this somewhere, I don't know where. Is the commercial list practice direction and trial requirements memorandum designed to discourage trials as a resolution of disputes? Could I fire that over to Lyndon Barnes to start with?
I guess that as a general observation, I would say that it's not intended to do that, but I suspect that it does. I think we can make some general observations that most commercial disputes are capable of resolution. And the costs of the disputes, by just the very fact that litigation has become tremendously costly, and the uncertainty of the results that one is going to achieve, even if the matter does go to trial, those are inherent motivators in any system for settlement. And the thing that I think that this panel and the discussions that you have heard this morning, the one difference between perhaps a commercial list trial and a trial in the general division is that it is impossible to wing it in the commercial court. You just cannot leave the case preparation until the night before, as you are able to in the general division. And because of that, I think that all of us know that one motivator for counsel to settle a case is the level of unpreparedness. I think that that in itself motivates many counsel to settle, just they're too busy to look at the case, they don't want to prepare the case. So when one looks at the requirements, one recognizes that in the commercial court, one is prepared for trial at a lot earlier stage. And that in itself, I think, facilitates settlement. I don't know if it necessarily drives a settlement or discourages a trial, because clearly there are disputes that go to trial, and they go to trial in a very efficient way. But I think it is a comment that if one works through the process of completing the trial requirements memorandum, one becomes aware at an early stage as to the weaknesses and strengths of the case. That's just as a product. The memorandum requires such a burden on counsel to communicate with the other side and agree on as much as possible. And as you're learning on what you can agree on, you're also learning as to the weaknesses of your case. So it just dictates that at an earlier stage, you're in a much better position to discuss settlement. The direction also, I think, puts an incredibly large front-end load on the cost of a case. Because if you use the witness statements that you've heard discussed this morning, even though that they're not necessarily intended to be a sworn statement, because there are many ways that you can go about doing it, they get prepared as if they're affidavits. So that I think costs, as we all know, become a very, very large factor in any settlement. And frequently, if you take a case that, let's say, is worth $500,000, $600,000, $700,000, and you know that it's going to cost at least $100,000 for each side to try that case, if you've got a swing of $200,000, then costs are a very large component of any settlement discussion. So I think that the direction in itself does drive people to having settlement discussions, but I think it also drives them to having much more meaningful settlement discussions. So I wouldn't say that it discourages trials, but it certainly, I think, is a motivator and a facilitator towards settlements. And I think proof is in the pudding, because I think that the statistics of cases going to trial in the commercial court will indicate that very few cases do go to trial. But I think on the other side of that, most people will feel that the settlements that they have achieved were settlements that were fair to both parties. People left something on the table, but they walked away feeling that they'd achieved a reasonable settlement. The one thing, though, just digressing from this, Peter, is that I think that Mr. Justice Farley's comments about costs are rather optimistic. I don't think that we really are at a position yet with clients that they're prepared to pay a substantial premium for settling a case at an early stage. I think that most clients, believe it or not, expect costs to be a very large component of the settlement, and frequently they want to know if the solicitors are giving something up to settle the case. They want the solicitors to be part of the settlement process. So I don't think that they're ready if you tell them that this is a wonderful deal, and by the way, I'm going to triple what my hours on the docket are to date, that at the present time would perhaps be more of a stumbling block towards settlement than an encouragement.
I notice there are a lot of young counsel out here, and I would feel an empathy for you because my experience in the commercial list is about as brief as many of yours, I suspect. My experience in the bench was a full first year on the civil list, and then starting this past Christmas, a 6-month term on the commercial list, which is coming to a conclusion. And it's really quite a striking difference in the two systems. For starters, in the 20 or 25 trials I probably did in the civil list in 1 year, I don't think there were more than 2 that had a fact situation in the 1990s. They all were the 1980s, and it's not just motor vehicle. The longest trial I had in my first year as a judge was 17 days, and it went with it dealt with a property transaction, a single home on Riverside Drive, and it went 17 days. And it was 1982 was the fact situation. 17 days on that. Commercialist is very pleasant to open your file each evening and see dates like 1994, 1995 most of the time. No 96s yet, no. My visual image of the two systems would be, in the civil process, sort of it looks like a donkey cart, which it's in a field, and it heads into Sherwood Forest, and you can hear the bells in there, and it always goes the same pace, never goes quiet, no one ever sleeps completely. And you hear a little bit of clip-clopping, and it goes clip-clopping on and on and on for about 4 years, and then pops out the other side, and nothing's really changed. The commercial list visual image I have would be a bit like the German Autobahn. You pull your car out into that outer lane, and all of a sudden there are lights behind you flashing a lot, saying, move fast or get out of the way. And that happens.
And who's driving?
There was one big difference, though. The donkey going through Sherwood Forest really can go through at the same pace the whole 4 years. On the Autobahn, you exit once or twice completely. You slow down from the 150 kilometers, and you go into a toll booth. And the toll booth has on it the big word settlement, just blazing in lights. And as you pull your Mercedes off and come through the toll booth, you may not have to come to a complete stop, but you're going to have to come down to almost a complete stop so you can throw your quarter or your loonie into it, Deutschmark into it. So in the commercialist, settlement is much more prominent as a component of the system than in the civil list. And I think that's a good thing. I think a good many of these cases can be resolved. There's usually both good arguments on each side. The parties, they may have been angry when they started this, but by the time they've got their first lawyer's bills, and by the time they get in front of a judge who's trying to be friendly with them and help them a bit, they realize that if they can duck out of this with a settlement, that's what they'd like to do. And the current system encourages that, in my view. The other thing the current system does is encourage, and Lyndon has said this, and so many other speakers have said this today, it encouraged a much more focused trial, if in fact the matter does come to trial. One of my impressions of civil trials was, and it came as a complete shock to me, was several of the trials went all the way through several days of evidence and the closing arguments, and plaintiff's counsel, for example, at the end of the closing argument would sit down and would not have said a word about paragraphs 1A to F of the statement of claim. The evidence meanders for 3 or 4 days. The closing argument then meandered. And you read the statement of claim and it says breach of fiduciary duty. And when the lawyer sat down at the end of a 5-day trial, it seemed like years sometimes, 5-day trial, the words breach of fiduciary duty or breach or duty wouldn't have been heard in the evidence and wouldn't have been heard in the closing argument. In commercial, because you're preparing the documentation, the lawyers are forced to focus on their claim. And because they're forced to focus on it, the actual trial will not have the impression of being a meandering stream. It will have the impression, for the judge sitting there, of being something that the lawyers have thought through, have focused on, and are going to present in a focused fashion. I used to work as Chief Justice Dixon's executive assistant at the Supreme Court of Canada before I moved to Toronto in the mid-'80s for a different job. And when I moved to Osgood, I was asked by the first-year teachers to give a lecture, since I was coming from the Supreme Court of Canada, on factum writing and trial advocacy. And I thought, well, why should I do that? Or I'll do it. But what I should do is interview a few of these Supreme Court judges before I go. And so I interviewed several of them. And something Justice Wilson said struck me as being quite appropriate. I asked her, has the charter made a difference in practice before the Supreme Court of Canada? She said, yes, a huge difference in the litigation. She said, my impression of counsel, and it's often young counsel, is that they are wonderful researchers, better than the generation before. They are very creative in the way they think about things. They often are quite articulate, but they have spent no time with all that mound of creative material they've found devising a blueprint of their case. And that's what they need to do. And my impression in civil is that there were often not blueprints of cases on both the plaintiff side and the defendant side. Whereas in commercial, because of the requirement of these various requirements in the practice direction and the memorandum, by and large, as a judge, I do see blueprints when I'm sitting there, reading it the night before, hearing the case as it unfolds, and trying to make up my mind. Counsel tend to be fairly clear on what they say their case is about. And I think that also is to be encouraged. So my answer to the question would be, does it discourage trials? No, it encourages settlement. And if settlement is successful, that will discourage a trial, which is a good thing. And it also, once a trial is called, it encourages a better and a more effective trial. I have not had a trial in civil, ever, that ended within the time limit that the lawyers estimated, ever. And often the gap is double. They estimate 3 days, it's 7. And they estimate 9. The property case, no jury, estimate of counsel, 8 to 10 days. Actual case, 17 days. 2 of the top counsel in the city on that case. I've not had a case in commercial where they have been outside the estimate. Now, a couple of times has meant that we start at 8 o'clock one morning because it's going to be the last day, or we go till 7:30 at night because it is the last day. But I have not had a single case, a motion, an application, an action that has gone outside the time limit in commercial.
Within the process and within the time limits, is there any room for advocacy left in the commercial list trial practice? Who wrote this question? Anyone want to tackle that one?
Well, I'll take a shot at it.
Okay.
I think that we shouldn't operate under the guise that all members of the judiciary are rocket scientists. And I think that probably the most successful advocates are the advocates that can reduce their case down to simplicity. And I think that's what Justice MacPherson was saying, that I think that what you have to do as an advocate is to give the court a blueprint to what you hope will be success, or a roadmap through the case. And one of the things that I would certainly appreciate hearing from the justices on this panel, as we go through the exercise of developing compendiums and putting together succinct witness statements, it sort of harkens back to the contrary position that was taken as to why you must read in each and every question from an examination for discovery, and that is obviously because you want to be certain that the judge is listening to those questions. So one has to at least pause as a litigator in the commercial court and wonder that even if you have gone to that exercise of preparing in great depth a lot of documentation, which hopefully is going to reduce the court time, you have to have the confidence that the court has in fact read that and distilled it in advance. And so I think that as an advocate, the one thing that you have to be prepared to do is to make sure that you highlight in the course of your argument the relevant matters that are contained in those documents, because you don't have the ability to know what impact, if any, that piece of evidence may have had on the judge, because the judge may not display any knowledge of it. It's something that gets passed over. It's not relevant. It doesn't come out in cross-examination. So we're putting a lot of confidence in the court to have a full comprehension of a lot of material that will not be touched in any manner in open court. So that certainly the advocacy skills are still there, because you've got to be certain that those facts that are not contentious facts, but they're extremely important facts. I think as Frank was saying, when you read in from discovery, you want to make an editorial comment on something. You don't have that opportunity to do that necessarily if you're simply filing a witness statement. So I think that the advocacy is still there. It's very much a part of the case. And I do worry a little bit as we give more and more to the court to read in advance. Are all judges going to read it in advance, and are they going to have a comprehension as to why, in fact, that material is before them? Because arguably, there's no sense putting material before the court if it doesn't have some degree of relevance. So I think advocacy certainly is very much a part of the commercial court.
Before we get to the judges, and before we consider whether there should be a quiz at the beginning of the trial as to the judge as to what was in the material, Frank Newbould?
I think the answer to the question is clearly yes. Advocacy involves persuasion. In the commercial court, it means taking a look at your documents before they get filed. What's the order of presentation? What's going in? What's not going in? That's part of an advocate's job. It's part of the persuasive job you have to do, and you start from the beginning. Advocacy also involves leading evidence in chief and cross-examination, and it's absolutely still part of the game in a commercialist trial. How you draft, as Peter said, you may want to have your witness dictated him or herself, but you want to have something in a persuasive manner put on a piece of paper. And most importantly, advocacy involves persuading a judge on the basis of the facts before the court. You can't throw in all the facts and say, there they are. Obviously, you've got to weave your web. You've got to bring it together. You've got to emphasize what's important. You've got to explain away why something appears to be against you isn't. That's all part of advocacy. It's all required. What underlies, I think, the question is, we've got so darn many rules here. We hear about this case of Lloyd's where the judge is going to call all the shots. There's nothing left to do. That's really overstating it, where there are rules to try to take a commercial case and try and boil it down and have it determined quickly and deal with the real issues. And that's all to the good, but that doesn't mean you don't be an advocate for your case.
Long before I became a judge, I read a biography of Earl Warren. This would be 10, 15 years ago, and he was asked the question by a law student at a speaking engagement once, what is the effect of advocacy on the decisions that you make as a judge? And he thought about it for a minute, and he said, I would say on the Supreme Court of the United States, 90% of the cases decide themselves, in my own mind. 3% of the cases are won by good advocates who should have lost the case probably, and 7% of the cases are lost by lousy advocates who probably should have won the case. I was thinking about those statistics this week when we were preparing for this session, and in my own case, and I can only speak for myself, those numbers are just nowhere close to being true for me. And it may be just because I know a lot less law than Earl Warren, although he was just a politician in California for a long, long time, and I wouldn't have thought there's a lot of law in being governor of California. But well, that's right. Reagan. I asked myself, what in the last 6 months on the commercial list, what effect would advocacy have had on my decisions? And my numbers would be these, roughly, give or take 10%. 50% of the cases decide themselves. 50% of the cases, when I've read the material carefully, the night before or the weekend before, and I do read the material very carefully. I think we all do on the commercial team, and I think in most of the court as well. 50% of the cases do decide themselves, and by that I mean I have a pretty good idea before anyone has said a word in court which way I'm going, and in fact nothing changes. Even really good counsel don't change it. But that means 50% of the cases don't decide themselves. Well, what happens to those 50%? Of those 50%, 45%, or 90%, depending which way you want to take it, but 45 of the 50%, I will have decided at the end of the argument when I leave the courthouse that night. And 5%, I still don't know what I'm going to do, and I have to take the books home and read everything and try to figure it out and flip a coin a week later. But 45% of the cases, from the moment lawyers get on their feet to the moment I pack my briefcase and go across back to 361 University, 45% of those cases which were not decided the night before are decided in my mind, and the decision won't change. I may have delivered it on the spot, or I may have reserved and do a short endorsement that night, or I may reserve and do a more elaborate judgment in the week or 2 weeks after that. But those cases have turned on good advocacy. And I think that, so my answer would be advocacy is really crucial in the commercial. I think part of the reason for that is, globally speaking, and I wouldn't make too big a point of this, but globally speaking, the law is, at least to me, more complex, and the cases are more complex at a factual level than globally speaking in the civil list. And I think therefore advocacy has a big effect when something's more complicated. And secondly, I think good advocacy often can flow from, always flows from, in part, good materials and the requirements of the memorandum and the practice direction mean that you're going to have good materials, and those good materials flow into the lips of counsel, it seems to me. So my answer too would be yes.
Justice Farley? Well, I guess what's the definition of advocacy? Maybe it's marshaling the relevant facts and the relevant law and presenting them in such a persuasive way to the judge that you are successful. What advocacy is not in the commercial list, I would think, is the liberal application of bovine fertilizer to baffle the brains. That's probably a reflection upon what Lyndon was saying. It's not rocket scientists that you get pretty low brain power, but certainly I agree with Jim MacPherson that advocacy is very important in any section of the civil list or the criminal situation, and it is particularly important in the commercial list. And Frank, if you want to, as a new form of advocacy, bring in the flashing neon light, highlighting the very important part of the examination that you're reading into the transcript, I think that would be marvelous. I think that you could probably draw my attention to that. But certainly, I mean, that why not? If it's a vital point, there's nothing the matter. In fact, there's every good reason to come into a case, and this isn't new. This is certainly not new. There's nothing new that we're talking about. It's common sense. But, you know, I got 3 points in the case. Here they are. Here they are again. And in summary, here they are again. Sit down 10 minutes later. Example. Recent case dealing with a motion situation where the lawyer was, I mean, this situation was so bad that the lawyer himself showed up to argue his case to get some judicial discretion. It was so bad that he couldn't fob it off on somebody else in the partnership to come and suffer the slings and arrows of outraged judges. He came in, I think probably The transgressions were so significant, and he sat around for about an hour listening to a couple of other cases, got on to the aspect. He was a quick study, said mea culpa, mea culpa, mea culpa. The test for this relief is three-part. It's conjunctive, not disjunctive. The only way that I can convince you to allow the situation is on the last part. And he went straight to it, and he won. And this was a transgression that was awful. This was something that had lain around for 10 years before it got on the list. This is a different case than the one I did yesterday, by the way. But he was persuasive because he got to the point and he emphasized that point, gave me the facts with respect to it. It was the only thing that he could win on, and he won. So yes, advocacy is very good.
Can I touch on another subject, which is just the complexion of the court? To some who may not be there all that often, it may appear to be a court that sort of has a small cadre of counsel who appear there all the time, and isn't a court generally resorted to by a broader cross-section of counsel. Is that so? Perhaps I could ask Lyndon Burns to start off on that one.
I think that that any person that practices civil litigation is going to be comfortable in the commercial court, providing that they've read the practice direction. I think that really that one just has to recognize that the practice direction, once you've been through it once or twice and you've filled out the necessary forms, that the comments that Mr. Justice Farley made earlier really are the ones that one has to be cognizant of, and that's the 3 C's. And if you understand the 3 C's, and they're pretty basic principles, and you've read the practice direction, and you carry with you Ashmore because it does come up quite frequently, and at least have it with you, you're going to be fine. It's no different than practicing across the way. So I think that even though people perceive that perhaps there are some people that are a lot more comfortable in the commercial court, you can become comfortable quite quickly. All you have to do is understand that there are certain guidelines, and those are the ones that have been discussed today, and there are people that are available to assist you in understanding them. As Trish says, if you've got a real concern, you can direct it to Charlie Scott at Torrey's, who's the secretary to the Users Committee. Belinda's very helpful. And if you have any difficulty, I think that subject to what Mr. Justice Farley would say, is that if you've got some concerns or you're having some trouble working your way through the system, go on a 9:30 appointment. The judges are very cooperative. The 9:30 appointments are just a wonderful tool, and I think the use of the 9:30 appointment is generally a little broader than perhaps is suggested in the practice direction. So I think it's just a matter of making sure that you read the direction before you arrive there, because as you've heard this morning, there are specific requirements to get you into the commercial court. But once you're there and litigating, a capable litigator is going to be comfortable in the court.
Perhaps I could just add that there may be some impression that it's only big cases that should go on the commercial list. I don't think that that's correct. Quite bluntly, I don't think that it's a place for the small claims type of case. On the other hand, the small claims type of case shouldn't be in the general division in any event in these courts. But we will tailor the particular process to make certain that the amount of money in dispute isn't completely eaten up and both sides go bankrupt, because we don't need the bankruptcy business either. Perhaps just speaking as to what Lyndon had said a little while ago, that I was perhaps over-optimistic with respect to convincing clients that you should receive a significant fee for resolving a case early. Yes, I agree that I'm optimistic. No, I don't think I'm Pollyanna with respect to that. But thirdly, I do say to you that read some of my judgments. I think that we on the bench owe the bar the obligation of presenting in papers or in judgments, and I have done it. Pepsi Cola and Backup was one of them, and my paper today, talking so that you, about this particular subject, so that you can go to your client and say, look, this isn't just me trying to stiff you. This is the reaction, the considered reaction of the bench to what is a fair way of dealing with the question of fees. And we certainly don't want any of the lawyers going bankrupt.
I'll just add one word. If there are some young lawyers out here who are interested in the commercial list, but haven't had a case on the commercial list, I'd encourage you to try to get one and to go through the process. I would say it would be good for you. You shouldn't be scared off. It is true that there are certain lawyers who come on the commercial list very, very regularly. I can see two faces in this room this morning. I've had them in front of me more in 3 months than any lawyers I've had in front of me in the civil list for over a year. But the nature of the work in the commercial list is conducive to a very broad range of lawyers using it. So if there are some younger lawyers who haven't done it, I'd encourage you to try to come on the list and take your first case on that list. In order to decide for yourselves whether you want to do that, I would say you only have to answer one question in your head. And the question is simply this: am I organized? Can I be an organized lawyer? And if your answer to that is no, then you shouldn't want to come on the commercial list. But then you shouldn't want to practice law either. So the only thing that's really different about the commercial list is fairly heavy organization. And I'd encourage you, if you haven't done it, to test yourself by picking a case and coming on the list.
Pick a winner.
They're all winners, too.
Is that a question?
I wonder how many other cases that you hear followed from basket, whether that's really an exception to you.
Basket clause, good question. Maybe a third, maybe a half. A substantial number of cases. Now, certainly that with respect to the time, because of course you realize somebody can trip me up because you say, oh, well, you do 25 bankruptcy discharges in a day and you only do one motion and summary judgment or something like that in a basket case. But quite clearly there's a very sizable percentage of basket clause cases. There was, on that respect, try your imagination. If you get the judge after they have heard 5 consecutive PPSA cases, you can get any case on.
My experience has been if it's interesting, they'll take it. So make it sound interesting.
I've done not a lot, but a half dozen or 8 basket clause motions. I think I've granted them all. 2 of the factors in my mind, one I've written in the endorsement and the other I haven't. But the one I've written is, the reality is that if a commercial case can be over and done within 3-4 months, whereas if you're on the civil list, you could be 2 to 3 years. And I just basically, when I get anybody in front of me saying I would like this litigation to move quickly, I'm simply sympathetic to that. So if they've had enough brains to think one way of making sure this case doesn't run 3 years is to try to get in front of a judge in the commercial list and persuade him or her that this involves money and money means commercial. Even if it's, used car lot in Whitby, I'm sympathetic, and that's one I'm thinking of actually. And the second reason is, and this is the one I haven't written, the second one I haven't written is often the basket clause motions with small amounts of money are being brought by young counsel. And I don't ask them, have you been in the commercial list before or haven't you? But in my mind, I'm thinking, well, they've had enough wit about them to try to go this route. They may have good reasons for their clients to do it, i.e. get it done in months rather than years. And they may just want to be introducing themselves to the commercial list. And so although I don't write that in my reasons, if they look young and are asking for the basket clause, I tend to let it in. That's why I'm off the commercial list at the end of June.
That's also why I'm off the commercial list for 6 months in criminal, starting July.
Well, looks like a lot
So,
of good people.
so the solution is get your oil of Olay out and come in and talk. I think that Jim's absolutely right with respect to that. Plus, one of the other factors, being in the smaller cases, it's quite often that when you look at the smaller cases, if you can get the counsel to talk to each other, if you can get the parties to talk to each other, if you can really talk turkey, a lot of the case sort of falls apart. You're able to reach a settlement sometimes with one 9:30 appointment plus a settlement conference. Just remember my old adage, you can't get blood from a stone, but you can get a little juice from a turnip if you massage it the right way. A lot of them just fall apart. It's not a situation where the parties can just go into ultra delay, hoping that they'll win the lottery. If they're on the commercial list, the matter will be heard in a reasonably short period of time. But what's the victory? The victory may be a hollow victory, so just work out terms of payment.
So the motto of that is you can get any turnip case in through the basket clause. Does every case have to be case managed down to trial on a relatively tight time schedule on the commercial list? Any views judicial-wise?
Well, I guess on that one, when I was reading these questions last night, that was the one I gave my personal bluntest answer to. And my answer would be yes. And it really doesn't relate as much to the nature of these commercial trials or the commercial process. I just think that the justice system in Ontario is so slow and so inefficient writ large that it is seriously bringing the administration of justice into complete disrepute in the eyes of the public. And therefore, I think that across the system, just not commercial, we have got to start case managing with some real rigidity if we are to dig ourselves out of the hole. And I'm not saying the fault on that is on individual judges or the courts. In fact, I don't think the large part of the problem rests with them at all. But wherever the fault rests, government, lawyers, court administrators, individual judges, it's a huge, huge problem. And so my view is part of the solution to the problem is to case manage things very rigidly. A few exceptions, you don't have to case manage every component right down to the day that's been suggested in the year-long schedule. But I do think you need to say that the beginning point and the end point are going to be absolutely crystal clear, and we're not going to vary those at all.
Any contrary views?
I can give an answer that's yes but or no but. So let me phrase it this way. I don't think that, and I've said this before, the commercial list is not a hurry-up court. If the parties and their counsel wish to schedule a trial for 1999, the only difficulty that we'll have is it'll take us about 15 minutes to find a 1999 calendar so that we can book that. So it's not a hurry-up court. If the parties want to take that, we assume for good reason, that particular course of conduct, that's fine. So it doesn't have to be according to a tight schedule in the sense of a compressed schedule, but it should be managed on the basis of what's a reasonable schedule. And assuming the parties agree, that's their schedule. If the parties can't agree, then they come before the judge, and the judge will determine what is reasonable in the circumstances. And I think erring and should err reasonably substantially on the side of quotes, reasonable delay, close quotes. Because I think that there should be some reasonable opportunity in a what I'll call a money case for the other side to have the opportunity to raise those funds. It shouldn't be a Lister and Dunlop situation of instantaneous demand or you're out.
I can't believe that I would ever have thought I would be less Foreign Legion inclined, i.e. march or die, than Jim Farley, but on this one I am. My response to the parties that come in and even for good reason say, we need you in 1999, would not be to get out my 1999 calendar. It would be to say to them very bluntly, come back in the summer of 1998 if you still need us, and we'll schedule you in 1999. But we're not putting you in our system with its short resources between now and 1999 just because you think that's convenient and sensible to your parties. I'd say come back later when we can help you.
Lyndon or Frank, do you have any cases that aren't on a relatively short fuse on the commercial list?
That are not?
Yeah.
No, I've got some, no, they're not. My experience is that it's a rare bird. I've never been involved in one where both parties have said we want to try it in 1999. And likewise, it's not a lot often both councils say we want to try it next week, although that happens more and more in commercial matters where both parties want to get the dispute over with one way or the other. But when you're in a trial situation, more often is the case, one party wants to move it, and one party wants to slow it. And that's the perfect time for case management to make sure that doesn't happen, to my mind. With everybody's got schedules and everybody's got intervening cases, and it's pretty easy to put things off and come up with half-decent excuses if that's what your client's interest is. And that's one of the big problems of the system. I'm basically in favor of what Justice MacPherson says. I agree.
Well, I guess, Peter, my comment would be that I think that we all benefit from the structure of the system, but something that goes at breakneck speed, I believe should only go at breakneck speed if, in fact, there's the urgency and the council agree to it. If, in fact, there's one council that wants to go immediately and the other council doesn't, I certainly would hope that the court will be entirely satisfied as to the urgency and the reason to go at breakneck speed. I mean, there's a balance here. I think that anybody who has done one of these 6-week trials, and I have done one, recognizes two things. It puts a tremendous drain on counsel that are involved, and secondly, it drives the costs up astronomically because you have to involve a lot more bodies to pull together one of these situations. So there's quite a burden on doing one of these breakneck speed trials, which do get done. But I would hope that they're only being done because the court is entirely satisfied that they've got to be done on such a short fuse. I don't have any luxury of going in and asking for 99 trial dates, but I certainly am going to approach that next week, now that I know it's available. But I do think there's
Go to him at 9:30.
before he goes to criminal court. But I do think that there has to be a balance here, because I don't think that every trial has to be tried sort of within 6 or 8 weeks of being started in the commercial court. So.
Were there any questions in the audience? Yeah.
Given the case management judge is so valuable to the system, why is it that the judges are being moved off the commercial list for 6 months at a time?
We burn out. We need to change. I mean, it's a pretty protein-rich diet, and particularly when you got a lot of papers to read every night and a lot of cases to decide and get the reasons out. So you do need, when I say R&R, I'm not saying that any other sector of the court is an easy side, but you do need some sort of variety. And yeah, but the good situation is that basically what you do have is a reservoir of judges who will be circulating in and out of the commercial list. There won't be a lot of new faces. There will be some phasing, but it'll be basically the same cadre.
A judge who's case managing something now is gone for 6 months and returns, is it likely that same judge would take back the case that he was managing before?
It would depend on the circumstances. likely that would be the situation, particularly if the judge who's been involved in the second, or the 6-month hiatus is off the list for that particular period of time. Keeping in mind that for a number of continuing matters, even if you are off the commercial list team, we do try to carry along some of the cases, and I have done that when I went off to criminal 2 years ago.
Going back to the basket clause for a minute, I was wondering whether the justices would approach a motion under that clause in the same way that they might approach a motion under Rule 3715, which is the motion that allows all interlocutories to be returned to a single judge if the matter is complicated or would otherwise cause delay or cost. Would the approaches be similar? Are there any parallels?
I don't know that that's a basket clause situation. I would think that that's just merely the section of the practice direction where we talk about the varying types of case management that you can have. But even if there is no request for a case manager judge, there is a lot of case management hands-on by the judge, particularly the one who's been the first one involved in a substantial way. We do like to try to keep that same judge involved throughout the piece. And if counsel are agreeable, the case manager judge could be the trial judge.
So then if the circumstances may warrant a motion under Rule 3715, it's the same set of circumstances, presuming we're dealing with a commercial matter, that would warrant a commercial list judge adding the matter to the list under the basket clause.
I just don't think it's got anything to do with the basket clause at all.
Yes.
Is the commercial list generally restricted to matters which have the greatest connection to Toronto as opposed to any other jurisdiction outside of Toronto, or is it possible to get a matter on the list that may have a greater connection to the jurisdiction outside Toronto but has a clearly commercial bent to it, or fits specifically within one of the clauses in the commercial list?
Is this true confession times, Mr. Debrezé?
Based on comments that I've heard from you before.
I like the question.
The commercial list is a Toronto region situation subject to an out-of-Toronto case coming on for reasons that are appropriate and you're convincing of the supervising judge. I would think that under most circumstances, if it's a non-Toronto connected case, the only way, or the only real reason that a case should come on is if it deals with a major aspect. And let me give you one example, would be the Algoma Steel restructuring situation under the Companies Creditors Arrangement Act. That probably would have overwhelmed the resources available. Plus, you had the fact that essentially all of the counsel involved in that case, because of the nature of the expertise and experience of counsel, were Toronto-based as opposed to Sault Ste. Marie-based.
Yes.
What is the procedure for getting an accurate meeting? How do you set that up? Or is it a letter?
Me?
Yeah.
Oh. You phone into the commercial list office and fax down a request to them. We suggest that you phone ahead to find out whether or not the 9:30 list for the next day or the Friday or the next Wednesday is completely booked up, or that they need to get another commercial list judge on the roster for that day to deal with 9:30 matters. If it's a matter of urgency, then there's no particular difficulty with respect to walking in. In fact, If it is a true emergency, there's no difficulty with respect to walking in and interrupting Mr. Newbould in the middle of his flashing neon light saying, I have a terrible emergency. Well, we'll either deal with if it is a terrible emergency, then we'll deal with it right then, or we'll deal with it at 4:30, or we'll deal with it whenever. If, on the other hand, it's not a true emergency, you may end up in the emergency room.
Sort of a mixed message. I wanted to just ask about one other subject, which was the ADR initiative that's starting up the beginning of June. 8 of 10 cases heading off in that direction. How does that relate to the commercial court cases, and how is it going to interact?
Well, I think that if people appreciate the origin of the ADR pilot project, you'll appreciate that there was a very strong component of ADR solutions already involved in the commercial list prior to the announcement of the pilot project. And that as we say, which is obvious, that council have the obligation to continuously canvass settlement. If that settlement will be facilitated by getting a judge involved and dealing with the matter on the basis of a mediation by the judge, a neutral evaluation, which is the way, I'd say an early neutral evaluation, as opposed to the pretrial situation where if you get a neutral evaluation, it's too late. A mini trial, anything of that sort, we'll do it. It may be that you want to talk over with the judge whether you can do it within the system, in the sense of having the judge do it or another judge do it, having it referred up to the ADR center for one of the dispute resolution officers to deal with it, or perhaps an exit or a detour to an outside neutral to deal with it. There are a number of very well-trained and experienced arbitrators, mediators, you have it out there, and it may be a situation where counsel are looking for a particular type of person. They may have some suggestions, we may have some suggestions. So in that respect, I don't think that the 8 out of 10 referrals are going to change our philosophy, because that was part of the philosophy in any event, to see whether or not the matter was capable of settlement through any particular ADR technique, including, lest I forget, what Justice Blair said in Olympia, New York, and that was that the bankruptcy and insolvency bar there, the commercial list bar, in essence, because everybody on the commercial list bar was on Olympia, New York. They resolved their matters by the oldest and most recognized ADR technique, negotiation. The commercial list bar, in that respect, are experts in alternative dispute resolution, even though they might not call it that. I remember when George Adams came after he was appointed, but before he was sworn in, he spent a day of his mentoring with me, and he, at the end of the day, and we dealt with half a dozen matters in varying degrees, and he said, boy, that was really interesting. He said, so much of your work was ADR, and I said, what's ADR? I didn't know what it was. So it's a new buzzword, but it's certainly a lot of old techniques.
Could you explain this new system, exactly when a case will move to the ADR center after it's instituted?
Under the pilot project situation, Frank, a case will be referred to the ADR center immediately after the first defense is filed in the case. First defense because there may be multiple parties. The purpose of waiting until defense is filed, because of course so many cases go undefended, so there's no sense in trying to deal with the case that is automatically dropping out of the system. And we thought that the first defense was the earliest that we could get it. Then, in theory, you have a 6-week time horizon to talk over with the other side what the case is all about and where your dispute is, because you have a 6-week appointment. Now, scheduling remains a very difficult situation, even probably more difficult in the ADR center than in the regular court, because you've got to involve your clients. So you've just multiplied the number of difficulties in scheduling. Tell the ADR center, talk to the other side. Communication is a watchword for ADR. Talk to the other side, see whether or not that date is a suitable date. If it isn't, tell the ADR center what are suitable dates, and they will try to accommodate you to cut down on the number of adjournments. But the interesting statistic is that people report back that they do not need the appointment because they have met, they have conferred, or they may not have actually met physically, they talk over the telephone, and they settle the case. And that's running at 20 to 25% month in, month out. That's an amazing statistic. The cases that go up to the ADR center that are not opted out, if the case isn't, if it's going to be a battle to the death, then people opt out, and then you hear the cries of the wounded. But opt out if you don't want an early resolution. If you do want an early resolution, then the mediation sessions up there are achieving settlements in about 60% of the cases that are mediated.
I can supplement those statistics. I phoned the ADR center this week just to see how they were doing and spoke to the director. And these are the statistics across the system in their pilot project. 50% of the cases that have an ADR session settle at that session. 75% of the cases that stay in the system settle at some point. Of the other 25% that settle at some other point, half settle before the session, as Jim was just saying, and the other half settle between the session and 30 days after. So a total of 75% of the cases settle, 25% don't. I had no views about ADR until I came into the commercial list, where we get referred as judges to sit in some of these ADRs, and I've done 4, and they've all been fairly major ones. And by major, I mean a lot of money, a long trial process ahead, and the ADR was scheduled for a minimum of half a day and a maximum of a full day. And 2 of them settled, both of them about 7 o'clock at night, having started at 10 in the morning, and 2 of them didn't settle, even though we worked till 7 or 8 at night. So my success rate is lower, 50%. But just when I think of the 2 that did settle, one of them would have been hundreds of thousands of dollars in legal fees and an 8-week trial at minimum, and it settled at the session. So it is a process that I wouldn't, if I had been here in November, wouldn't have had any view on one way or the other. But I would recommend it to you. There's very little to lose. A half day or 1 day with your clients and someone doing the ADR with you, a judge or one of the officers up there, is a very good use of your time and your money, even if it doesn't succeed.
I only had one other point that I wanted to touch on, which was that combined process that Frank Newbould talked about earlier. He mentioned about having an application in which there was a little bit of viva voce evidence, and that's a procedure that I'm sure not many of us have thought about, and I'm just curious about Frank's experience with it and what room there is on the court to have this sort of hybrid application.
My situation, the parties did not want to have a trial of the issue and have a dispute for 6 months. The business wouldn't have allowed it. So both parties wanted to get the thing over with, and that's what drove that kind of an agreement. One way or the other, whoever's going to win or lose recognized it couldn't continue on because of the effect on the business. If you don't have counsel agreeing, I'm not sure how you achieve it. It's a great way to avoid an order that there's going to be a trial of the issue with all that that involves later on. But without the client's consent, I'm not sure how you do it.
Well, essentially, then you dealt with affidavits and cross-examinations, but for some selected evidence?
Yes, in this case, I wanted to call my client the plaintiff because I wanted the court to take a look at him. I also called some other people who were outside people who had relevant evidence, so that made sense. I wouldn't have filed an affidavit on their behalf, but I called them to trial. The other side did the same.
Is there scope for that?
Absolutely. I think that you can get any sort of hybrid into the commercial list for the way to deal with witnesses. What Frank was mentioning, having witness statements for some witnesses in total, having them under cross-examination, having them warmed up for a half an hour or an hour, and then going under cross-examination, dealing with some witnesses completely viva voce from start to finish, and others in some other fashion, whatever is suitable for the occasion. One size does not fit all.
Any other questions or thoughts before we break up? Well, thanks very much, everybody.